Are you a tenant with an initial or further initial hearing scheduled in Landlord-Tenant Court? My name is Jordan and I'm a housing attorney at Neighborhood Legal Services Program. In today's video, I'm going to give you some tips if you're representing yourself in court without a lawyer by sharing the 5 do's and don'ts of initial and further initial hearings. If you'd like a more in-depth explanation of what an initial hearing is and how to find out if you have one, watch the Tenant's Guide to Initial Hearings video linked at the YouTube channel in our bio. To see if you qualify for free legal assistance, call the Landlord-Tenant Legal Assistance Network. The information in this video is not legal advice, and it is specific to courts in Washington, D.C. because the laws vary across the country. Let's get started. Number 1, do not miss your hearing. If there's an emergency, you can call the clerk's office and ask for something called an emergency continuance, which could postpone your case. The number for the clerk's office is in the caption below. Remember to arrive at your hearing at least 10 minutes early, which you can do in person or remotely. Do not log off of your hearing or leave the courtroom until you have heard your name and case number called. Number 2, do not admit that you owe money without explaining your legal defenses. Legal defenses are reasons why your landlord should lose the case. We have a separate video on this topic if you'd like to check it out. In general, common legal defenses are things like housing conditions issues, maybe mold, broken windows, broken AC, heating, or maybe it's mistakes on your rent ledger, the record of rent payments that you make in a non-payment of rent case. Now, if you admit that you owe money without explaining your legal defenses, you may lose your chance to tell the court your side of the story, and you can even lose the case. Number 3, do tell the judge if you have a pending ERAP application. Some judges will choose to postpone your hearing while ERAP application is being processed. It's not a guarantee, but it is important to tell the judge. Number 4, if your landlord requests a protective order, do ask for a bell hearing if you have problems in your housing that your landlord has not fixed, or if you dispute the amount of rent that you owe. So what is a protective order and what is a bell hearing? Well, a protective order means that your landlord will ask the court that you pay your rent into the court registry rather than to your landlord while your case is ongoing. At a bell hearing, you can argue that the amount that you should pay into the court registry each month should be lower than your rent because of housing conditions issues. Number 5, when in doubt, do ask for more time to speak to an attorney, called requesting a continuance. If you'd like the summary of this video in written format, feel free to take a screenshot of this flyer, front and back. You can check out this flyer as well as all of our other flyers on pro se tenant topics at the website linked in our caption. To find out if you qualify for free legal services, call the Landlord-Tenant Legal Assistance Network. Good luck!